Once again, is there all these principles which would be applicable for a PIM to this set of mediation and
Post-court mediation has this restriction insofar as settlement is concerned. It has to be accepted by the judge, whereas pre-court.
And how did you change their mind to amicably resolve the issue? Can you share us like some of your experiences in this regard?
Particularly the stakeholders like advocates and the commercial stakeholders, they have to avail this because they are looking for a forum where they want to air their grievances, try to get an opportunity where they meet in a neutral platform.
So when you said that there is an option for parties to go for mediation or to avail any other form of dispute resolution, once again, is there all these principles which would be applicable for a PIM to this set of mediation and area as well? Like the party autonomy, the confidentiality?
Yes, you are right. Simply note, there also it is mediation.
Yes.
If it is referred after court, filing of a case in the court, that also is a mediation. So the principles of mediation there, as also here, remain the same. The autonomy, the confidentiality, the neutrality, all that will be there. Probably the two differences is, one, pre-institution mediation, there is a mediation fee payable. Post-institution, that is to say, after filing of the commercial case and referring to mediation, it is free as of today.
Okay.
There is no need to pay.
Okay.
There is another advantage. If the matter is resolved in post-institution mediation, if it is settled and there is some court fee which is payable, which has been paid, that also gets refunded. Another big difference is, pre-institution, the settlement is arrived between the parties and the mediator and signed by all of them, and it becomes a decree.
Yes.
Here, whatever is settled is going to be a proposal of settlement. It will come back to the commercial court before the commercial judge, and he will say, accept it. If it is all within the legal framework, then only it becomes a decree.
Okay.
So post-court mediation has this restriction insofar as settlement is concerned. It has to be accepted by the judge, whereas pre-court, pre-institution,
parties
can themselves decide. So there are some advantages, some disadvantages.
Yes.
It all depends on how we understand it.
Yes.
I would say, Veena, we the advocates, we have to have sensitization on this.
Yes.
Then we'll be able to convey this to the parties, who may see which is better for them. They may opt to settle, they may not opt to settle. As you rightly said, finally, it's a party autonomy process. He decides what he wants.
Yes. So now coming to, you would want to know what your experience as a lawyer, as an advocate, a mediator, as a lecturer, as an author, the last several decades that you have practiced. Can you share us some of your very special experiences in these different roles where you would actually see how these laws actually help people to arrive at some settlement?
Yes. See, when I started practice, the Arbitration and Conciliation Act 1996 was not in place. The Legal Services Authorities Act was not there. I still remember when the new law was introduced, people went to Parliament. They also went to the President of India saying that don't bring these laws.
Yes.
When the amendment to CPC took place in the year 2000, where they brought in some restrictions saying that written statement has to be filed in so many days.
The time
limit was prescribed.
Yes.
That also brought in Section 89.
Yes.
Thanks to that 89, though we all protested,
and
we went, and finally it became a history where the Supreme Court said in Salem Bar Association case that mediation is a compulsory process which it's a process which we have to accept. Thanks to 89, now mediation after Section 89 has been introduced has resulted in another mediation concept which is pre-institution.
Pre-institution mediation.
So we are also evolving.
Yes.
We were all used to that typical litigation mentality.
Yes.
Now slowly we are also realizing that litigation is also required, but first we have to see whether it can be resolved.
Yes.
We as advocates,
we
are also doing quite a few mediations.
Yes.
What we thought that was mediation.
Yes.
I used to call my opponent party and make my party and them agree.
Yes.
But we had a limitation.
Yes.
For that party, I am only an advocate for this party.
Yes.
So you used to always come with a frame of mind, he is my opponent's advocate.
Yes.
But here, the mediator is a neutral third party who is not interested or having any interest, beneficial interest in this result, I mean in the result which their parties are taking.
Yes.
So this is a neutral third party.
Yes.
So this concept is totally different.
Yes.
So I would say this is a game changer. This has definitely helped the mindset.
Yes.
It is time that the people, that is to say, the stakeholders, namely the advocates, the litigants, the judiciary,
Yes.
welcome this new legislation and try to see that the ease of doing business
Yes.
is improved.
Yes.
If ease of doing business is improved,
Yes.
economy improves,
Yes.
civilization improves,
That will have a repercussion.
repercussion
Yes.
all over.
Yes.
India grows.
Yes.
I grow, India grows, therefore we all grow.
Yes. So, can you tell us in any experience as a mediator? So, you are also a mediator. So, when you are sitting as a mediator and there are two contesting parties in front of you, maybe not through lawyers, by the parties themselves, how could you influence their minds? How did you address some of their apprehensions? And how did you change their mind to amicably resolve the issue? Can you share us like some of your experiences in this regard?
When you told about an example of contractor,
Yes.
I remember one such instance which has also come in the mediation.
Yes.
The dispute is pertaining to some mediation where the dispute subject matter of difference, that is to say specified value, was 2 crores.
Yes.
Contractor could not afford to go to the court, wait for the result to come and have the uncertainty pending on him, which means the money is blocked for so many
Yes.
years.
Yes.
He approached mediation. Fortunately, the other side also was able to
Agree for the
mediation.
Yes.
In the process, it was settled for a very nominal amount,
Yes.
where both parties went with win-win situation.
Yes.
So probably if this concept was not there, the advantage would have been lost.
Yes.
The parties would not have had this advantage.
Yes.
Now the concept is there, they are here to take the advantage of it. And I find that the people are waiting for these opportunities. This would definitely help the parties in resolving most of their matters.
Yes.
Because unless it is such a serious dispute where you require an adjudication by a judge, most of the matters can be resolved in the mediation.
Yes.
And pre-institution is a concept which probably will help them to agree to agree, or if there is a serious disagreement, respectfully disagree.
Yes.
So in a mediation, it could be agree to disagree, or agree to partly agree and partly disagree.
Disagree.
Even partly agree, partly disagree, it can narrow down the scope of the dispute
Yes.
later,
Yes.
for the later dispute.
Yes.
So this
And also
concept,
you mentioned how after litigation as well, the mediation post litigation or
Yes.
during the course of trial. So that option is also
that
very-
option is also there. So that's also another aspect. So I would say this is a welcome legislation.
Yes.
We had to take use of this, particularly the stakeholders like advocates and the commercial stakeholders. They have to avail this because they are looking for a forum where they want to air their grievances, try to get an opportunity where they meet in a neutral platform.
Yes.
Now that is set up.
Yes.
It is not a court, but something in the shadows of the court,
Yes.
where you do all this and try to get the best out of that.
Yes.
And still you are reserved.
Yes.
Now these commercial stakeholders cannot say courts are delaying,
Yes.
because you are now given an opportunity,
Yes.
utilize it.
Yes.
You take this.
Yes.
If you then are forced to go to the court, then don't blame the court for the
Yes.
delay, because you have chosen to go to the
Yes.
court. I think this is a
Yes.
change which we are seeing in this commercial court
Yes.
pre-institution mediation.
Yes.